For more than 47 years, our nonprofit, Resources for Seniors, has supported older adults and caregivers in Wake County. We can help in many different ways, including adult daycare programs, ramps and repairs, in-home supports, and consultation and referrals. Indeed, we're who to call when you're not sure who to call. Resources for Seniors stands ready to support you in your caregiving journey.
I'm Mark Costley, the founding attorney of Clarity Legal Group, the Triangle Area estate planning and elder law firm. You know those people who become overwhelmed dealing with the multiple challenges of being a caregiver? Clarity Legal Group helps people establish legal tools that avoid confusion, give them peace of mind, give them asset protection, and in some cases help them qualify for Medicaid. We help people get it right in the face of some of life's most important challenges. We don't just provide wills, trusts, and powers of attorney. We provide solutions and ongoing support. We provide clarity and peace of mind. It would be a privilege to help you.
Are you like 80% of seniors who would like to age in your current home? Call Wisdom Senior Care. Are you currently taking care of a loved one and finding yourself frustrated, tired, and even lonely? Call Wisdom Senior Care. Always available, dependable, and flexible. Come partner with Wisdom Senior Care, keeping wisdom at home.
Hi, I'm Jonathan Williams. I'm an attorney with Clarity Legal Group. We are a local Triangle law firm. We do estate planning, we do elder law, we do estate and trust administration. We have attorneys and staff in our office. I'm here today with my colleague Mark Costley. We're going to be talking about healthcare directives and the role of the healthcare agent. So we're going to be talking about healthcare planning today, and we're going to be talking about it in some detail. A little bit about myself. I'm a graduate of Wake Forest. I also did my law school at Wake Forest. I've been practicing in the areas of estate planning and elder law for about 10 years now. My coworker Mark, who's next to me here, is a Duke graduate, also Duke Law School. He's been doing estate planning and elder law for a good 30 years now. So between the two of us, we've got a lot of experience in this area, and we deal with these issues a lot because those issues are really all our firm does work on. So we're happy to bring this information to you today. So our objectives today, a lot of people have signed healthcare directives, they've signed healthcare powers of attorney, living wills, HIPAA authorizations, but they don't always revisit these documents. They don't think about them on a regular basis. Sometimes these documents get signed and then they don't get pulled out again until some sort of health crisis happens. And so we want to give you this information as a way to think about these roles, to think about these documents in a new way so that if and when the time comes that you need to use them, that it's not a surprise to you. And in fact, you may learn something today that helps you understand a little bit more how these things work and may cause you to want to make some changes to how your healthcare planning is done. Healthcare planning is a common part of any estate plan that you do. It often includes a healthcare power of attorney. That's a legal document where a principal names a healthcare agent to make medical decisions for them if that's ever necessary. Also a living will, which deals with end-of-life decision-making, and then also a HIPAA authorization, which is a medical privacy waiver. And we're going to talk all about those, but we're also going to talk in some detail about the role of the healthcare agent. How should they think about approaching their job as making medical decisions for someone who's unable to do that? So that's going to be the main goal of the second half of our presentation. So first, let me introduce you to the healthcare power of attorney. The healthcare power of attorney is simply a legal document signed by someone referred to as the principal. The principal names someone called the healthcare agent, and the healthcare agent is the person who will make medical decisions for the principal if the principal ever loses the ability to do that for themselves. And when you're doing a healthcare power of attorney, not only are you naming a healthcare agent, in an ideal case, you're also naming some successor healthcare agents, maybe a backup, maybe even two backups, so that if the person you choose as your healthcare agent is unavailable to serve, either because of their own health issues or any other reason, that you've got someone else in place who can make medical decisions for you when the time comes. Now, when you name a healthcare agent, they don't immediately have the ability to get involved in your medical affairs and talk to your doctors and start changing your medical plan. They only will have power to act if and when your doctor determines that you no longer have the ability to make and communicate your own healthcare decisions. Only if that happens will the healthcare agent then be able to step in. So what kind of powers does the healthcare agent have when the healthcare agent is serving under the healthcare power of attorney? Well, it's a pretty broad and comprehensive grant of authority that you give your healthcare agent when you do a healthcare power of attorney. You're giving someone the authority to make medical decisions for you, to make mental health decisions for you, to make decisions about treatment, to make decisions about whether you ought to be admitted to a hospital or nursing home or any other kind of treatment facility. Also provides informed consent on procedures and medications and all sorts of things. That being said, the healthcare power of attorney does give the principal the opportunity to make limits on their healthcare agent's authority. For example, if the principal had moral or religious objections to certain kinds of medical treatment, well, we can say in the document, I don't want my healthcare agent to be able to consent to this kind of treatment because of my beliefs or my priorities. And it doesn't have to be moral or ethical. It could also be just practical. We've had clients who are up in years and they've had multiple instances of cancer treatment, and they've decided, I'm old enough, if the cancer comes back, I don't want chemotherapy and radiation again. Well, we can put that in the healthcare power of attorney if we want to. Now, it's not common. Most people that we deal with don't want to place limits on their agent's authority. They want their healthcare agent to be able to do anything they could do, and more importantly, do anything that their doctors might recommend. But we can more narrowly craft those powers if we need to.
And Jonathan, if I could jump in there just for a second. I want to say that most of my clients, when they ask us about these things, they want things to work well. They want things to be simple. And so there are a couple of points to remember about this. These healthcare powers of attorney are very state specific. So the formats for these differ from state to state. There's a different statutory scheme for each of them. So we almost always advise people to have documents created under North Carolina law. But you were talking specifically about the issue of placing limitations on the agent and saying you're prohibited from doing this and prohibited from doing that. Well, one of the themes you're going to hear about for the rest of the presentation is that we put a high value and a high premium on having conversations with the people you name as your healthcare agent so that they know what your wishes are. And we can keep it simple by putting fewer strict limitations on the agent in the legal document and dealing more with direct conversation with the agent so they understand what your wishes are.
Thank you, Mark. Now, in addition to the powers that you grant your healthcare agent during your lifetime to make medical decisions for you, the document also allows you to give your healthcare agent some powers that will take effect upon your death. That includes the power to make decisions about disposition of remains, like where would you like to be buried or would you like to be cremated. You can say in your healthcare power of attorney that you want your healthcare agent to carry out your wishes with respect to the disposition of your remains. You can also give your healthcare agent the power to donate organs for you if you're an organ donor, or if you want to make an anatomical gift to a medical school or to a research center. You can authorize your healthcare agent to make anatomical gifts as well. Another thing that the healthcare power of attorney commonly does is it will nominate the healthcare agent to serve as guardian. That way, if a guardianship is ever necessary, we have the healthcare agent nominated where we're telling the court, hey, if I ever need a guardian, this person here is the person that I really trust to be making decisions about my health care and my housing situations and things like that. Now, part of the reason we do this planning is that we don't want to go through guardianship, and we'll talk a little bit about that in a little while, but we do have this in the healthcare power of attorney as well. Now, how does the healthcare power of attorney work in practice? Well, essentially the healthcare agent, if they are called upon to make decisions due to the incapacity of the principal, they stand in the shoes of the principal and they will make decisions as if they were the principal. Now, they have to work within any limitations on their authority that may be included in the document, but if there are no limitations, then their powers to act are pretty much comprehensive. Now, there's in the context of end-of-life decision-making, there's another document that may come into play, that is the living will. Mark's going to talk in more detail about the living will in a second, but if you're the healthcare agent and we're dealing with an end-of-life situation, you're also going to be wanting to consult the living will to see what it says about your principal's wishes regarding end-of-life decisions. But again, the healthcare agent doesn't have any power until the doctor says that the principal is unable to make their own decisions for themselves. Now, when you're thinking about your role as a healthcare agent, we're going to go into some real detail about that in the second half of this presentation, but here's just a little preview. In an ideal world, if you are a healthcare agent, we're gonna expect and hope that you will have had conversations with your principal so that when these issues come up, you have some sense of what your principal would want because you've had conversations about these things. And even in the event that you don't talk about a specific instance in the course of those conversations, we still hope that you will have had enough conversations with your principal that you have some sense of their values and their priorities and their goals when it comes to medical treatment, so that when you're exercising your authority as healthcare agent, you're in a position to say, well, this is not what I want, this is what I know my principal would want, and make the decision based on what you know about your principal. So I'm going to wrap it up there on healthcare power of attorney and hand it over to Mark, who's going to tell you a little bit about the living will.
Thanks, Jonathan. So Jonathan talked about the healthcare power of attorney, and there he's talking about empowering someone else to act for you. The living will is what's called an advanced directive, and it's structurally the opposite. It's you making a decision in advance, putting it in a legally enforceable form as an instruction to your doctor or your healthcare provider about what kind of care you want at the end of life. And so in this document, again, you're laying out your wishes and you're putting them in an enforceable fashion. Your healthcare agent will still interact with the living will in effect as an advocate for you, but the decision is yours. It deals only with end-of-life decisions. We recommend that people use the North Carolina statutory form if they're in North Carolina for this, although we can modify that and adjust it as we're going through this. Now, this document is dealing with life-prolonging measures. Life-prolonging measures are not defined in the statutes or in the or really any place. Okay, life-prolonging measures are what your doctor or physician or healthcare provider intends with respect to this. So when we're saying I don't want life-prolonging measures in certain circumstances, we're saying, doctor, I don't want you to do anything that you would be doing for the purpose of prolonging my life. Now, a living will is a vital document, okay? This directive will state what your wishes are really in 3 core situations under the North Carolina form. If you're at the end of life and your death is going to certainly occur relatively soon, if you have advanced dementia and you have no possibility of regaining mental capacity, or if you're permanently unconscious and your doctor says it's a medical certainty you're never going to regain mental capacity. So the living will, this legal document will give directions that really reflect your values and your choices about health care, and you'll say, well, do everything necessary to keep me clean, keep me comfortable, keep me free of pain, but you'll have specific instructions about circumstances in which you don't want care. Now, how does the living will relate to the healthcare agent? Well, so the living will is your direction, it's to your doctor, and your healthcare power of attorney is going to be an advocate for you. Your healthcare agent steps into your shoes and can do anything you can do unless you limit them. And that's a really important thing to consider. So here's the deal. I can always change my living will. I go into the hospital with a written, signed, notarized living will. If I have a conversation with the doctor that says something different than what the living will says, I have in effect, for at least for the purposes and period of that treatment, I've amended the living will. I can always change my living will. Well, my healthcare agent, when I can't make my decision, steps into my shoes, and my healthcare agent can always amend my living will unless I limit them. And in fact, it's really common for people to limit the agent with respect to that. It's common for people to say, you know, this is my decision. I want to remove the burden of this end-of-life decision from my family members or from my loved ones, and I want to make this decision myself to make it easier for them. And of course, I also want to have the certainty of knowing that I've gotten the outcome I want. So with this kind of planning, you can stipulate, in fact, it's a specific question in the North Carolina living will, do you want your healthcare agent to make the decision, or do you want them to be bound by your decision? Now, if you bind them to your decision, they're still going to be an advocate for you. They're still going to be thinking about making sure that they get a second opinion if they need a second opinion. They're going to be talking to your doctor and asking questions. They're just not going to be able to change the decision. The next thing I want to talk about is another critical document in this healthcare planning triumvirate, and this is the HIPAA authorization. We tend to treat this as a standard form, but we need to understand what it is. The HIPAA authorization is a waiver of your federal medical privacy rights as to certain specifically chosen people. It doesn't give these people any power to make decisions. That is your healthcare power of attorney, which not only clarifies who you want to make decisions, but can give them some specific guidance. The HIPAA authorization allows people to speak to your doctor, allows your doctor to speak to them. And of course, you want anyone who's named in your healthcare power of attorney and perhaps other important legal documents to have that ability, but you may want to and should feel very comfortable naming people who aren't decision makers. Maybe you have other family members who, if you were hospitalized and unconscious, you would want to be able to come to the hospital and speak to the nurse at the station outside your room, or speak to your doctor about your condition, people who you'd want to be able to review some of your medical records, but you don't want them to make healthcare decisions. It's okay to list them in the HIPAA authorization. In fact, it's a pretty good idea. We always encourage clients to revisit this because you would be surprised, but people at different stages of life have different opinions about who they'd like to have access to this information. It sometimes is a very narrow people when people are younger, well, maybe just a couple of people, and then as they age, they start to think, well, I'm comfortable with a larger number of people having access to this information. So again, make sure you have the HIPAA authorization and have it work in conjunction not only with your healthcare documents, but if you've done other planning, like a power of attorney or a revocable living trust, it's a good idea to have the fiduciaries in those documents have the ability to talk to your physicians about capacity as well, because they may be in a situation where they need to prove your incapacity in order to trigger certain powers under the document. Jonathan, I'm going to turn the floor back over to you and let you talk a little bit about what happens if you don't plan.
Yeah. So we want to address the possibility that you may have someone in your life that you're providing care for who has never done these documents and hasn't done any healthcare planning. How does that work? Well, there is a statute in place that says who has the authority to make medical decisions for someone who hasn't done this sort of planning. And we've laid out on the slide here some of those people who are mentioned in the statute. You'll see the first one is a court-appointed guardian. We'll talk in a second about guardianship and how that's really not a very pleasant process, and we'd like to avoid it if possible. But certainly a guardian would have the ability to make healthcare decisions. Second on the list would be your spouse, if there's a spouse, but of course not everybody is married. And so then the next on the list would be a majority of parents and children who are available to weigh in on this decision. After that, majority of reasonably available siblings over age 18 who are available to weigh in on this decision. And then at the bottom of the list is any individual that you may have a relationship with who basically shows up at the hospital and purports to act in good faith for your benefit. So, there's some good takeaways from this and the bad takeaways. The good takeaway is that if you haven't done healthcare planning, there is going to be somebody who's available who can make medical decisions for you. The bad takeaway is that you don't know who that's going to be, and you may not like who that is. You may have children that you don't trust making these decisions, or you wouldn't want to be involved in that situation, or siblings, and so putting a healthcare power of attorney in place will override all of this, and in most cases make it so that we don't need to go through guardianship either, so that the only person who would have the authority to make medical decisions would be your healthcare agent. But if you don't do a healthcare power of attorney, these are the folks who would be lined up to make medical decisions for you.
Jonathan, as you mentioned these rules, I was thinking about the potential for really a disaster or a conflict where we had multiple children or children and spouses, particularly if the spouse isn't the parent of the children, and a potential for conflict as a result of this. And you can see how that could be a nightmare. We'll get the question a lot of times, even when we're doing planning, well, can I name all of my children as co-healthcare agents? Can I have 3 children put to the task of making all of the decisions together? And the answer is yes, but the answer is also that it's not always a good idea. So when you're doing planning, you want to think about the real practical consequences of this. When someone's making decisions for someone they love, it can be an emotional time, it can be a stressful time, and so you may not get the best version of all your children that you're thinking about in that situation. So you want to think about whether or not having them in a potential where they might disagree or have conflict is really the best thing.
Great, thank you, Mark. Now, I want to talk a little bit more in detail about guardianship, and particularly why we want to avoid guardianship. Guardianship is the traditional way that the law deals with incapacity. The traditional way would be that someone loses capacity, and therefore someone else has to take them to court and allege that they become incompetent, and ask the court to declare them incompetent and to appoint a guardian who can step in their shoes and take care of things for them. That's the traditional way. Now, there's some advantage to this in that it's all court supervised, it's all public record, but for most families it's nothing but tremendous disadvantages because, again, you're having to haul your loved one into court. They've got to get served by the sheriff. We've got to have a legal proceeding that's going to be like a mini trial where evidence has to get introduced. It's on a strict time frame, so it's not something that can happen quickly. It happens over weeks or months. And because we're dealing with the court, we're also putting everything on the public record, and we are having, in most cases, to hire attorneys to help guide you through the process and do the legal filings. And so all these costs and hassles and the time-consuming and emotionally draining nature of guardianship makes it such that it's something that most people would want to avoid. And part of healthcare planning and part of estate planning generally is to plan for the possibility that you might become incapacitated someday, and you want to make sure you've put a healthcare agent in place, you've put a financial power of attorney agent in place, or maybe a trustee in place, so that if you do become incapacitated, you have people who have the legal authority to pick up and do things for you without having to go to court, without having to go through the cost and the time and the emotional energy associated with guardianship, which is really just not much fun for anybody at all. And so that's why we're doing this planning. And a lot of people are surprised, I'm married to my spouse. If something happens to my spouse, can't I sign documents or do things for my spouse while him or her is incapacitated? And the answer is no. Just because you're married, you don't get to act on behalf of your spouse. You're two different people, and you can't act for one another unless this legal authority has been granted in some sort of contractual or legal arrangement like a trust or a power of attorney or a healthcare power of attorney. So that's the background behind what we're doing. Now we're going to talk in some detail about the role of the healthcare agent, and particularly the role in the context of dementia and diminishing capacity. So Mark's going to go into some detail about that, and then I'll come back later.
Okay, so as you know, we really think of the healthcare agent as acting only when the person who's the principal is unable to make their own decisions. Well, where does that line occur? How do we know? Well, the answer is that's something that a diagnosing physician decides, okay? Typically, the attending physician is going to be the one who's going to decide whether or not the person can make their own decisions. What do we do to assess capacity? If you're the agent in waiting, the healthcare power of attorney in waiting, what do you do to assess this? Well, you need to ask some questions of yourself as to the condition of the principal. What do they understand? Do they understand what's going on around them? Do they have problems remembering things? Are they able to understand the pros and cons of certain decisions? In effect, every time we're having a conversation with anyone, regardless of their capacity, we're assessing whether or not they hear us, right? I say something to you and I'm listening to hear whether or not your response reflects that you fully understood what I said. Well, so we're really in a way trained over a lifetime to be able to do that, and that's what we need to be doing for someone who's having challenges with capacity. We need to be listening really well to hear whether or not they're understanding and comprehending everything that's going on. We also need to understand that incapacity exists on a spectrum, that these kinds of challenges can be different at different times of day. We know all have dealt with someone who has a harder time remembering things late in the afternoon than they do early in the morning, make decisions better at one time than another. We also have people who have significant memory problems, and we need not to conflate memory problems with judgment problems or capacity problems. There are people who cannot remember what they did a couple of hours ago who understood fully what they were doing when they did it, okay? So the fact that they have a memory problem does not mean they lack the judgment or the capacity to make decisions. It just means that they are sending you cues that send off whistles for you and make you wonder. Well, be careful about conflating memory problems with incapacity. The tools that you have for assessing capacity are important, okay? Ask whether or not the principal is able to explain their options when you're presenting something to them. Ask whether or not they understand the consequences of what they're doing. Do they know who their family is, who their loved ones are? Do they know who their doctor is? Do they know, what the challenges of a decision are? That's really what we're looking for. We're not looking for whether or not they're making the best decisions or whether or not they remember all the elements. We're looking for whether or not they understand what they're doing at the time. Does the principal repeat questions over and over over? Do they have that's often a means of sort of masking or covering that they're not understanding things. So again, you're looking for those cues that might cause you to think that they don't understand what's going on, but you're also looking for an opportunity to conclude that they do. When someone actually is suffering from dementia, you want to think about what's in their best interest. You want to think about how you give them every opportunity to stay in the game. Because when you're making healthcare decisions for someone, what you're really doing is trying to carry out their wishes. And I think it's a starting point for almost everybody's wishes that their personhood, that their integrity be honored. So when we're looking at this kind of thing as for what their ability to make financial or legal or other decisions are, we're looking for opportunities to confirm that, yes, this person does have the ability to do it. So it's critical to create a framework in which the principal's wishes are honored. You also want to think about, if you're serving as a fiduciary for someone, whether or not there are things that they need to do to take care of their affairs. And the reason I say that is because so often it is the case that someone who is having capacity problems is on this continuum and they're going down. Okay? And so they may be competent today to do things like express their wishes with respect to important decisions, to write a will, to establish a power of attorney. And so when you notice or get the cue that someone's having problems, one of the first things you need to think about is, well, do they have all the things they need in place to take care of things when things get worse? And so don't assume they don't. So I'll just talk about a will, for example. Someone writing a will doesn't require that they have great insights into their affairs. It requires that they have basic understanding. So do they know who their family is? Do they know basically what they own? Do they understand what a will does? If they meet those criteria, we're going to be able to do a legal document for them. In fact, technically, someone can have been declared legally incompetent by a court and still be competent to write a will. It's not likely, but it is technically possible. So we always want to make sure that we look at this person with declining capacity and make sure we get everything taken care of for them. So what's the perspective of the healthcare? What happens if the prospective healthcare agent, you, the healthcare agent in waiting, thinks the person is not competent, but the doctor assesses it and says, no, I think this person can still make their own decisions. What do you do in that situation? Well, often this can be a really important point because you feel that the person is making bad decisions or not making informed decisions. The doctor has reached a different conclusion. Well, you can encourage a second opinion, but you don't have the power to require a second opinion. Why is that? Well, because the healthcare agent has the power to ask for a second opinion, but you're the healthcare agent in waiting, and you have no powers until the doctor triggers those powers by saying the person is unable to make their own decisions. Now, you've got a HIPAA authorization, right? So that empowers you to talk to the doctor and empowers the doctor to talk to you. It doesn't give you decision-making authority. So you can perhaps consult another physician using that HIPAA authorization. You can get medical records, okay? Because the HIPAA authorization entitles you to have medical records and carry them to another physician to make an assessment, for example. In a worst-case scenario, you could force a guardianship proceeding which would give you control. But again, you have to assess what's in the best interest of the principal in this challenging situation and do what you think's right. When it comes to dementia care and the healthcare agent, Jonathan, would you like to take this and talk about it a little bit?
Yeah, so if you're the healthcare agent and you're assisting someone who has dementia and your powers have been triggered, right? If the doctor has confirmed that you are now the healthcare agent because the principal you're working with is unable to make decisions anymore, a part of your role will be to think about not only their healthcare situation but also their housing situation. Is it safe for them to live at home alone? That's part of your role as a healthcare agent. And so we have here listed on the slide some signs that you need to look for, signs that a principal may be unsafe to live at home. They include, of course, missing appointments, poor hygiene, inappropriate dress, inability to manage things like medications and meal preparation and household tasks. And of course, as the healthcare agent, you can make this assessment in concert with a medical professional like a doctor, a geriatrician, or maybe even a care manager who can help you essentially figure out what the principal is still able to do for themselves, what they need help with, what supports would they need to live at home, or is it now an appropriate time to think about relocating that person to a place where their needs can better be met.
So when do you get a second opinion, okay? When do you need to pursue a second opinion? Well, it's when you're not really sure. You're not really sure whether or not someone has capacity. When it keeps you awake at night, okay? When you wake up worrying about the person you're responsible for. When you have serious concerns about the challenges the person's facing, what about the significance or irreversibility of the decision? All of these things are things that can cause you to want to consult perhaps a specialist or someone else who can guide you in making this decision. Remember, capacity is not a monolith. It's not something that is a black and white thing. And I think the decent and compassionate thing to do for anyone is to be looking for ways to find them still competent and to keep them in the game with respect to their decision making. And so that's why as we go through this presentation, we're going to talk a little bit about how you make decisions and what criteria you use. When you get a diagnosis, it's time to plan, okay? It's time to think about not only treatment options and planning options, thinking about getting access to technology and other things, but it's also the case that effective planning is going to cause you to make better decisions. So as soon as you get this diagnosis, you want to take in all the information that is necessary so that you can begin to plan to make outcomes that are really closely aligned with what the person you're making decisions for would want. The more information you have, the better those decisions are going to be. So I'm going to let Jonathan take over a little more talk about being a healthcare agent. Jonathan, take it.
Yes, thank you, Mark. We want to finish up with a detailed description of what it means to be a healthcare agent, and if you are a healthcare agent, how you should think about your duties and how you should think about your role and how you tackle this job of being a healthcare agent. Well, the first place we want to look is the law. North Carolina law says that the healthcare agent has the power to make healthcare decisions to the same extent that the principal could make those decisions for himself or herself, except as they may be limited in the document, as we already know. Well, what does that mean? You've got the power to make decisions, but how should you exercise that power? What guidance does North Carolina law give you about how to exercise your power as a healthcare agent? Well, there is one provision in the law that says, with respect to mental health decision making, that the healthcare agent should be making decisions that are consistent with what the agent believes the principal would have wanted to happen if they had the ability to make their own decisions. And so there is some sense in the law, at least as to mental health decisions, that the agent should be using the principal's priorities when it comes to exercising their power as the healthcare agent. Now, that only applies under the law to mental health decision making. The law is silent as to other types of healthcare decision making. But we still want to think we still want to think about it. And as you recall, at the very beginning, we said that the healthcare agent really should be thinking about what would the principal want. What have we talked about? What do I know about their wishes? And then if I don't know what their wishes are, what do I know about their values and their priorities and their goals for healthcare treatment so that we can understand how best to get the outcome that the principal would want, which is really our North Star here. Now, in the absence of a lot of guidance from state law, we offer this model called supported decision making as an alternative way to think about your role as a healthcare agent. This actually is a legal framework that is part of the law in some states. Not very many states at this point, but more and more states are adopting supported decision making as a model for how a guardian should act when they're making decisions on behalf of a ward who is incompetent. And we think that it is a very good model for a healthcare agent making decisions for a principal under a healthcare power of attorney. So let me tell you what supported decision making is. Supported decision making is something that we all do all the time in our everyday lives. Anytime you consult an auto mechanic, an attorney, a tax accountant, anyone who knows more details about a situation and rules and options than you do, you are engaging in supported decision making because you know there's someone who understands these things better than you do, and you're asking them to explain your choices in a way that you can understand so that you can make an informed choice that's consistent with your wishes. That's to supported decision making. So our analogy here for the healthcare agent is that the healthcare agent is that trusted advisor, is that auto mechanic or that attorney or that accountant who has a better understanding of these issues than the principal does because of the principal's declining capacity. So to the extent we can serve in that role as trusted advisor and explain options, and explain information in a way that the principal can understand, then we can help that person continue to make decisions at a more basic level where they can still understand, and we can honor those wishes and carry them out so that the person that we're giving care to is more likely to get an outcome that they want and get treatment that's consistent with what they would want. So let's think about the fundamentals here. So sort of our ethical fundamentals when we're thinking about supported decision making. These are the propositions that every person has the right to make choices about their own life, even if they're incompetent, even if they're incapacitated. As long as they have the ability to communicate and make choices, we want to honor those choices, and we want to communicate with that person because we believe they have the right to make choices about their own life for as long as they're able to communicate. And we also believe that if we are able to explain things in a way that they can understand, that person will make choices that are good for them and consistent with their wishes to the extent they can understand their options. So when it comes to supported decision making, really the bedrock of the practice is communication. How well can you communicate with your principal about their options and about the situation? Again, think of the analogy of the attorney or the accountant who can say, there's a lot of complicated rules, but let me break it down for you in a way that you can understand it even though you don't have the training that I do. And so as the supported decision-making healthcare agent, you can talk to the doctor, understand options, understand the situation, and then explain it at a more basic level in a way that your principal can really wrap their mind around it, even though they lack the higher level thinking ability due to their declining capacity. So having those conversations, it's not easy, especially in the context of a caregiver relationship where there's this back and forth all the time, and that can be a difficult relationship and a difficult communication. But it's so key, and we believe that engaging in this process will make everyone's life easier. Because if you're the healthcare agent, you can make sure that you're doing your job properly and getting the input of the principal when it comes to making these decisions. And in turn, the principal can feel like they're not being cut out of decisions about their own life, that they still have the ability to give some input into what happens to them. And so they're going to have more confidence in you as a caregiver and more confidence in you as a healthcare agent that they're getting what they want and that they're being listened to, and that's going to make that relationship work so much better because the person that you're giving care to has that much more confidence in you. So it's an important way to think about this. Yes, Mark?
So Jonathan, I was going to add, as you hear Jonathan's explanation of this and the kind of role that you want your caregiver to take when they're serving as your healthcare agent, it helps you understand who you ought to choose. And that's because one of the things that you need in order to deal with this is time. So often the person who's helping is pressed for time because they're living other aspects of their own life. They may have their own children who they're taking care of, and maybe they're your adult child who's been thrown into the role of being a healthcare agent. Well, it's not just about making decisions in a crisis. It's about having the time to have these quality conversations, to seek out outside advice so that we can make the best decisions possible. So again, when you're thinking about who to name as your healthcare agent, often you ought to be thinking about very practical issues like who has time, who has access, not just who's the obvious person.
Thank you, Mark. So if you are a healthcare agent and you want to think about your role as the healthcare agent in these terms of supported decision making, here's the bare essentials. You always, always, always want to consult with the principal. You want their input. You want to involve them in decisions about their own life, even if they can't understand all the details. Being able to give input in their own life and their own choices is going to be so important to them. Carefully explaining the issue is very important. Explaining the different options and how they work, explaining risks and benefits, making a recommendation. Of course you should be making a recommendation because, again, you have a higher level of understanding than the principal does. So being able to say, these are the different options, this is the one I think is right for you, and this is why, can really help that person, again, feel like you're taking care of them as their healthcare agent. Allowing, in the end, though, the principal to make their choice. So if you explain it in a way that you believe they can understand, and you've made a recommendation and you've weighed the pros and cons and explained those to them in a way that they can understand, then when they make a choice, we can feel confident that that choice is consistent with their wishes. And there's a little bit of a tension there, because if your loved one is making a decision that you don't agree with, that can be really difficult. You may think that they're making a choice that's not in their best interest, and you think they ought to be making a different choice. Well, one issue might be that you didn't explain things well enough, or you didn't explain them at a basic enough level that the person really understood the nuts and bolts of that decision. Or on the other hand, it may be the case that you explained it perfectly well, and they do understand what the choice is, and they're simply making a choice that you disagree with. And so you have to navigate that, and that is a difficult terrain to navigate. But in the principles of supported decision making, we weigh very heavily the input of the principal. Again, even if they're incapacitated in a formal sense, as long as they're still able to communicate and have some understanding, we believe that they're going to be making decisions that are consistent with their wishes. And so we really like to err on the side of letting the principal make decisions about their own life. That doesn't mean that you don't offer your concerns and say, hey, I'm not sure that this is a good decision, and here's why. But in the end, to the extent we can honor the wishes of the person who's there and expressing their wishes, I think that's a better outcome for everyone involved, and we like that model. And then once that decision is made, then your role as the healthcare agent is to inform the doctor and help carry out that choice so that we're moving ahead in a way that is consistent with our principal's wishes. So when we're applying this kind of analysis as a healthcare agent, we're using the principal's wishes and values as a guide and really as the fundamental bedrock here. The healthcare agent can use supported decision making to ensure that their duties are carried out in a way that's consistent with the principal's intent. And that's true both before and after the healthcare agent's powers have been triggered by the attending physician. Now, of course, there's going to come a time in many people's lives where they really are unable to meaningfully communicate anymore, either because they've lost consciousness or because their dementia illness has progressed to a point that they're really not meaningfully communicating in any way at all. So, of course, at some point, this kind of analysis will stop, and then we're left with the healthcare agent saying, well, since he or she can't communicate anymore, what would they have wanted? And use that as a guide, as opposed to having these conversations. But things have to go a long way before we get to a point where someone is non-communicative in any kind of meaningful way. So another role that you have as a healthcare agent is coordinating caregiving services for someone. And this kind of goes back to what we were talking about in terms of housing decisions and when's it safe to live at home and what kind of supports need to be in place at home. If you're the healthcare agent, another part of your role will be to think carefully about that. What kind of services do we need? What kind of people do we need? What kind of facility might we need to house someone so that we can make sure that all their needs are being met? And part of your role as the healthcare agent would be to coordinate those services and make those happen, line them up in a way that they're going to happen to support your loved one. So, healthcare, we talk a lot about estate planning and how people tend to procrastinate when they're thinking about estate planning. They really drag their feet and they don't want to take the leap and get it done. And obviously, as estate planning attorneys, we believe very strongly that earlier planning is better, but that's magnified so much in the context of healthcare planning and particularly dementia, because as soon as you know that you need to do healthcare planning, you want to do that as soon as possible so that the principal who is making these legal documents, making these choices, deciding who should represent them as their healthcare agent, can do that with as much capacity as possible.
So, Jonathan, if I could talk a little bit about this issue of trying to drive into the principal's goals and concerns and trying to make the decision they would make in the healthcare context, I want to contrast that with like a financial power of attorney. So if you are named as the agent under a financial power of attorney to deal with someone's financial affairs in the event of their incapacity, or to serve as their successor trustee in the event of their incapacity, well, suppose they have some assets that need managing, and you need to decide how they should be invested or how they should be spent. If the principal in that case had a history of making really lousy decisions or taking really extreme risk, your job is to stop doing that. Okay? Your job as the financial power of attorney is not to continue doing what the principal was doing. If they were taking extreme risk, your job is to do what's prudent, to do what's appropriate, to take reasonable measures to safely invest the assets. So you're going to exercise your judgment rather than theirs, where you find that they were making poor decisions. And sometimes people do make poor decisions. But when it comes to this healthcare context and trying to make healthcare decisions for someone, you're really never going to be in the position of substituting your judgment for theirs. What Jonathan's been talking about is the concept of trying to make, as best you can, the decision they would make. And so if your philosophies, your ethics, your religion, your views of healthcare are not in line with the views of the agent, or rather not in line with the views of the principal, you're not going to substitute your values or your perspectives. You're not going to do what you think is right. You're going to do as best you can what they would want. And so it's a different task in this healthcare context versus the financial context. One of the challenges we see in our practice is what happens where the principal, let's use adult children and a parent, a mom. What happens when mom's perspectives on what she wants changes over time? Because we do see this, and we see this quite a bit. As people age, they will go from saying, do everything possible to keep me out of a nursing home, spend every last dime I have to keep me out of a nursing home, and then at some point, when they're 10 years older, they may say, the most important thing to me is to preserve an inheritance for my kids. If we have to, set me up in an arrangement where we're protecting my assets and getting me in a nursing home, and because that's a less expensive way to care for me, go ahead and do it. Well, how do we know when we're the healthcare agent for that person which mom it is that we're going to follow? Which set of preferences are we going to follow? I don't know, Jonathan, if you've dealt with that. What do you think where you've had the situation where mom, the principal, has changed her judgment, changed her position over time? Are we following what we think is the best mom, or are we following what we think is the most recent mom?
Yeah, Mark, that's a really interesting question. I don't think there's an easy answer to that question. When we think about the principles of supported decision making, what we're trying to evaluate is the mom that's talking to us right now. Does she understand the consequences? Does she understand the issues? Does she understand the pros and cons? Or is she confused? And if we believe she's confused, we might need to have more conversations to clear up the confusion or get to the bottom of it. But in the end, if we believe that mom has genuinely changed her mind, then I believe we should err on the side of doing what the mom right in front of us is telling us she wants.
Jonathan, I think that's right, but I also think that it's an interesting cue for you as the agent, particularly if you have multiple family members who have a real interest in taking care of the principal. Because sometimes we'll have family conflict where, let's say, a decision-making adult child, the healthcare agent, is making decisions based upon these kinds of conversations, and there are other kids who are maybe a little bit less involved in taking care of mom who are saying things like, well, mom always said, I remember mom saying, I remember what they remember is what mom said 10 or 15 years ago, and the person who's actually making the decisions, the healthcare agent, they're kind of on the front line, and they're in the position of making the hard decisions. And they're in the position of having these conversations to try to draw out mom's real feelings and real preferences. Well, so being careful about this, bringing in outside advisors where appropriate, and even taking the time to document what you learn can really help smooth over those potential conflicts between the kids. Again, as we said before, it's an emotional time. It's a time when people are feeling a lot of stress because they're seeing a declining parent or dealing with just the practicalities of serving as a caregiver. And we want to make sure that we don't let that become a point of conflict for the family as they're making decisions for someone, because everybody's doing their best, but also people have different perspectives.
Great. Thank you, Mark. One last thing we do want to tell you about before we go. We have actually authored a book about caregiving, and we want to let you know about that. It includes information about estate planning and healthcare planning and planning for incapacity, also information about Medicaid eligibility, arranging for home care, arranging for institutional care, estate and trust administration. It includes a lot of information that will be really useful to caregivers. And what we've talked about today is just a little slice of that. And so if you have some interest in getting a copy of that book, you can be in touch with us or our office, or with Transitions Guiding Lights, who can put you in touch with us about getting a copy of that book. And then finally, we'll open it up for questions. So anyone who has questions that would like to ask us, now is a great time. We'd be glad to answer your questions. Thank you very much.